Good morning. Welcome to today's discussion, where we will explore a deeply sensitive and profoundly important question. Should parental rights be limited due to a parent's severe personality disorder? This issue touches upon the core of family life, child welfare, and individual liberties, making it a complex ethical and legal challenge. We are privileged to have two distinguished guests with us. Ms. Sarah Chen, a child psychologist, will argue for the necessity of such limitations in specific cases to safeguard children. And Mr. David Miller, a human rights lawyer, will argue against, emphasizing due process and the fundamental nature of parental rights. Our format will include opening statements, rebuttals, a moderated discussion, and closing arguments. We aim for a respectful and informative dialogue that illuminates the many facets of this difficult topic.
Thank you, Dr. Vance. The core of my argument today rests on a principle I believe is paramount: the unwavering right of every child to safety, stability, and a nurturing environment. When we discuss severe personality disorder in the context of parenting, we are not referring to common anxieties or mood fluctuations. Instead, we are addressing persistent, deeply ingrained patterns of behavior and thinking, such as profound emotional dysregulation, a severe lack of empathy, chronic impulsivity, or significantly distorted reality testing that directly and negatively impact a child's development and well-being. These are not abstract diagnoses. They manifest in tangible ways within the parent-child dynamic. Imagine a child raised by a parent incapable of recognizing their emotional needs, or one who consistently exposes the child to chaotic and unpredictable behavior, or worse, subjects them to emotional cruelty stemming from their own distorted perceptions. Such environments can be deeply damaging, leading to long-term psychological scars, an inability to form healthy attachments, and a perpetuation of dysfunctional patterns into the next generation. While every effort should be made to support families and provide treatment, there are, regrettably, instances where the severity and intractability of a parent's disorder render them fundamentally unable to provide minimally adequate care, regardless of the support offered. In these specific, rigorously assessed circumstances, where a child is demonstrably at risk of significant harm, the difficult decision to limit parental rights becomes a necessary, albeit last resort, measure. It is an act not of punishment towards the parent, but of protection towards the child, whose vulnerability demands our most careful and courageous consideration.
Dr. Vance, Ms. Chen, thank you. While I share Ms. Chen's profound concern for child welfare, I must begin by emphasizing the gravity of what is being proposed. The state intervening to limit or sever the fundamental right of a person to be a parent. Parental rights are not granted by the state. They are a cornerstone of individual liberty and family autonomy, recognized as such in most democratic societies and international human rights conventions. The idea of curtailing these rights based on a, quote, severe personality disorder diagnosis is fraught with peril. Firstly, psychiatric diagnoses, particularly for personality disorders, can be complex and are not always definitive. There is a genuine risk of misdiagnosis, subjective interpretation, and the potential for these labels to be weaponized in contentious family situations. Secondly, to limit parental rights based primarily on a diagnosis rather than on clear, demonstrable evidence of harm or neglect sets a dangerous precedent. It risks shifting the focus from a parent's actual conduct and its impact on the child to their mental health status, potentially stigmatizing individuals and creating a slippery slope towards eugenicist thinking. We must remember that many individuals with mental health conditions, including personality disorders, are capable and loving parents, especially with appropriate support and treatment. Our primary approach should always be to offer robust support services, therapy, and interventions to help parents manage their conditions and improve their parenting skills. Limiting parental rights should be an absolute last resort, undertaken only when there is clear and convincing evidence of sustained, severe harm or neglect to the child, and when all other less intrusive measures have been thoroughly exhausted and failed. The standard of proof must be exceptionally high, and due process meticulously followed, to protect against potential abuses, and ensure that such profound decisions are made with the utmost caution and respect for fundamental human rights.
Mr. Miller raises valid concerns about misdiagnosis and the fundamental nature of parental rights, and I want to address those directly. My argument is not for a simplistic, label-based approach where a diagnosis automatically triggers the limitation of rights. That would be unjust. I advocate for comprehensive, multidisciplinary assessments by qualified professionals when a severe personality disorder is suspected and impacts parenting. This means a thorough evaluation of the parent's functional capacity, their insight, their engagement with treatment, and the direct, observable impact on the child. The concern is not the diagnosis itself, but the demonstrable behaviors and environment stemming from the disorder that create a high risk of harm. Current systems often act reactively, waiting for overt abuse or severe neglect, which can mean prolonged exposure to emotional abuse and developmental harm for the child. A framework that considers severe, treatment-resistant personality disorders, which demonstrably impair parenting as a significant risk factor, allows for more proactive protection. This isn't about punishing parents, but about recognizing situations where a parent's condition, despite all support, prevents them from providing a minimally safe environment, thereby safeguarding the child's future.
Ms. Chen speaks of comprehensive assessments, but the practical application remains problematic. Assessing, quote, impaired parenting capacity linked to a personality disorder involves subjectivity, more so than evaluating concrete evidence of physical abuse or neglect. Who decides the threshold for sufficiently impaired? What if experts disagree, which is common in complex psychiatric cases? We risk a system where assessors' biases could unduly influence decisions about family integrity. Focusing on a diagnosis as a quote-quote risk factor can stigmatize individuals with mental health conditions who already face prejudice. This could discourage parents from seeking help for fear of losing their children, which is counterproductive. The emphasis must remain on the parent's timed behavior and its actual impact on the child, not the diagnostic label. If a parent's behavior constitutes abuse or neglect by law, existing child protection laws should suffice. Are these laws inadequate? Or are we trying to create a shortcut to intervention based on a predictive model tied to a diagnosis, rather than proven harm? This predictive approach is dangerous when fundamental rights are at stake. The potential for error and injustice is too high.
Ms. Chen, could you specify red flags within a personality disorder that you believe invariably lead to harmful parenting warranting severe intervention?
Dr. Vance, consider persistent inability to perceive a child's emotional needs due to extreme narcissism, or chronic, unpredictable rage creating a terrorizing environment. Another is a parent whose distorted reality, perhaps from schizotypal disorder, leads to neglect of basic safety or harmful child-rearing practices, resistant to intervention.
Mr. Miller, if not by considering the disorder's impact, how can the system protect children from sustained emotional harm or neglect that's detrimental but not overtly physical?
Dr. Vance, sustained emotional harm and neglect are provable through diligent social work, observation, and documentation of behavioral patterns and their effects on the child, such as developmental delays or severe anxiety. My concern is attributing this primarily to a, quote, disorder for intervention, rather than the observed harmful behaviors themselves, risks preemptive action based on diagnosis.
Mr. Miller, what is the acceptable threshold of documented emotional harm before intervention? Must a child endure years of damage before we acknowledge the parent's condition, due to their severe personality disorder, makes them incapable of change, even with support?
The threshold must be high, showing clear, significant detriment. Investigation takes time, a safeguard against unjust removal. Incapability of change is a profound judgment. We must exhaust support and treatment. Focus remains on impact, not a prognosis of untreatability as the sole trigger. Ms. Chen, how much weight should be given to potential rehabilitation or support for parents with these disorders if they show willingness to engage before limiting rights? Are we too quick to deem them untreatable as parents?
Significant weight must be given to genuine engagement and positive change. The goal is family preservation. However, with some severe disorders, capacity for insight and sustained relational change can be profoundly limited. This must be balanced against the child's developmental timeline. A child cannot wait indefinitely for stability that may never materialize. In closing, I want to bring us back to the silent party in this debate, the child. Their right to a safe, stable, and nurturing upbringing must be our unwavering priority. Limiting parental rights is an exceptionally grave measure, one that no one approaches lightly. It is not about punishing parents for having a mental illness. It is about acknowledging, with courage and clarity, that certain severe, intractable personality disorders can render a parent, despite all available support, fundamentally incapable of providing the minimal safety and care a child needs to thrive. We need a system that combines rigorous, fair assessment and robust due process with the willingness to make difficult decisions when a child's entire future is at risk from demonstrable, ongoing harm directly linked to such parental incapacity. Protecting these vulnerable children is not just a policy choice, it is a moral imperative.
I must reiterate the profound sanctity of parental rights and the inherent dangers of a system that might preemptively penalize individuals based on a medical diagnosis, however severe it may seem. Our focus must steadfastly remain on proven, ongoing harm to the child, assessed through the highest standards of evidence and due process, not on predictive judgments tied to a parent's mental health status. Before contemplating the termination or limitation of parental rights, a state action with devastating consequences, we must ensure that all avenues of support, treatment, and family preservation services have been genuinely exhausted. We must remain vigilant in protecting individual liberties against potential state overreach, even when such actions are motivated by sincere concerns for child welfare. The alternative is a path paved with good intentions, but fraught with the peril of injustice and the erosion of fundamental freedoms.
Thank you both, Ms. Chen and Mr. Miller, for your deeply thoughtful and articulate contributions to this complex discussion. It's clear that navigating the tension between vigorously protecting vulnerable children and steadfastly upholding fundamental parental rights requires immense wisdom and careful balance. We hope this debate has provided our audience with valuable perspectives to consider on this critical issue.